All right, good morning, everyone, and welcome to another edition here of the Justice and Pieces guest speaker series. And today we have uh, Bruce Parsons, who's going to join us here and tell you about Docket Watch and all the fantastic things he's been doing as a paralegal. So thank you, Bruce, for joining us.
Well, thank you for inviting me. It's a pleasure to be here.
And perhaps maybe you could tell us and tell all the students here a bit about your experiences there, as well as about Docket Watch.
Sure. So I became a paralegal in about 1997. I did take a college course at a private college, Success Business College. I took an advanced, what they called an advanced paralegal program, so it would have been an accelerated program. And it was very eye-opening. It was a second career for me. And accidentally, I got lucky because they taught me computer skills, which I had none of, as well as the legal stuff. And as you know, it was impossible, or it is pretty much impossible to function without those skills. So initially, I started out in a paralegal office. There was a single paralegal who I basically co-opted with for my time in school. She shared office space with a lawyer. So I got to do some service for him, some family law materials for him, and as well as the typical paralegal experience. Our materials that we learned in school, it was prior to regulation, so we used primarily the bar admission courses, and we were taught primarily as a dual stream, what you would think of as a dual stream paralegal law clerk course, which of course has ups and downs, but certainly we got much more of the Superior Court stuff than it would be permitted under the current regulatory regime. From there, I went out on my own for a little bit. I did a year of real estate and intellectual property type, some of the internet law in its infancy for a year with a company called Wright and Associates. And then I became the head person for a litigation department for a leasing company. We went national, had gone national, I guess, and we were a B funder, so we did a lot of special deals. I learned about the Personal Property Security Act and in all 10 provinces and 3 territories, and the litigation rules in all those places, because we retained an instructed counsel during my time there in all those provinces. And I did all the small claims stuff in Ontario for them. After that, I bought just as regulation came into being, I bought a traffic practice from an older paralegal that was established, and brought my small claims and landlord-tenant knowledge. I had done some mortgage work with Equirex as well, and we had done some landlord and tenant work, and did primarily traffic for the next 6 or 7 years. And since then, I've been basically operating as a sole paralegal, doing small claims, landlord tenant, and POA in a more specialized manner. I tend to take only certain cases. So I got involved in the profession during the regulatory process. I sat on a committee called the Judges and Paralegals Advisory Committee. There had been a number of town halls, and there's a town hall coming up this evening that all of you should be getting into to take a look. You'll see the treasurer from the Law Society and a lot of the paralegal benchers and the president of the Ontario Paralegal Association. They'll all be speaking about what's going on in the profession right now. So I advise everybody to log in at 6 this evening and take a look at that. From there, we went from the Judges and Paralegals Advisory Committee, went into the different organizations, the Paralegal Society of Ontario, PPAO, and was president of the Paralegal Society during regulatory introduction, if you will. So that's the background in terms of how I got involved in the profession itself. In terms of Docket Watch today, perhaps we can tie it a little bit more into what you're learning. You're learning about litigation and evidence, that sort of thing, as it comes together. And part of your course, you'll always go and you will watch what happens in court. That's always something that you do. And even though, regardless of how excited you are about what's going on, rarely do you have a good moment where it gets exciting or even interesting watching stuff in court. The reason is because you don't have the background to know what's going on with the individual cases. So you have to try and guess what the case is about, guess what the paralegals or lawyers are presenting, why they're presenting it, what the evidence is, what they have to prove. And all those things are, if you make a wrong guess, you don't know what's going on, you don't know what to expect, you don't know the law in the particular area because you haven't researched it. And it's painful. Watching court is, there's a reason why Judge Judy is made up in a lot of ways, and they handpick their litigants, right? They want to make sure that they're exciting. So let's start with maybe a quick question. What is our job as paralegals? So somebody comes to see you, what's the job as paralegals? Let me see if we can get, you can just post an answer in the chat here and I'll take a look and see if I can see the chat to see what we get for answers.
And if anyone is brave and wants to just unmute and answer the question directly, please do so as well. And remember, you're learning litigation and advocacy right now, so it's a perfect chance to advocate. To see something here from Darka.
There we go. Yeah. To represent your clients competently and provide access to justice. Very good. Anybody else?
If you can't provide representation under the paralegal scope, to refer the client to someone who can. So a lawyer probably.
All right. So you're the guard to the legal system. You're to make sure, and that's an important point because I think that's the point that I wish to make. You don't necessarily, you're not there to get a client. You're there to assist people. So if you can do it, you do it. If not, you get it to somebody who can. That's an important concept. But basically, the most important thing to remember for all of us is that our job is to help people. So somebody comes in with a problem, and your job as a paralegal is to help that person with that problem. Right? Now, think about it like this. We have a different skill set. So, for instance, if your car has a problem, you go see the mechanic, right? And the first thing the mechanic will do when they take a look at your car is they'll diagnose the situation. They'll take a look and see. You may not need a mechanic. Your car might be out of gas. That's why it won't start. So the mechanic will say, go put some gas in the car. You don't need me. And you have, as a paralegal or a legal representative, to know when that's appropriate, right? You don't need me. This is not a legal issue. Go here. But more importantly, the concept is that you need to get, you want to get your head around is that you're there to help somebody with the problem. You need to understand the problem and understand that you have a toolbox, if you will, full of legal wrenches. But you don't only have to use those legal wrenches. Sometimes communication can resolve an issue. Thinking outside the box, it doesn't matter how you get to where your client wants to be, provided you do it within the guidelines. But you have, your job is not to go to small claims court. It's not to follow a set legal process. Your job is to assist the client. And those are the tools that we use to assist the client. And that's very, very important. So when you're looking at, for instance, a litigation case, a small claims case, the very first thing you look at is there a cause of action, right? Does my client, when I listen to them, does it sound like they've been wronged? And does it sound like there's a cause of action? The second thing that you have to consider is, can my client get paid? Right? So for instance, a landlord comes to see you, they've got a $25,000 award from the landlord tenant board. They need it enforced in small claims court. They want you to do these things. The landlord then provides you with the information on the tenants and who are the defendants, right? And both of those people are on disability or they're on social assistance. You cannot garnish those things. If they have no other assets, then even though your landlord has a cause of action and a completed cause of action, you can go enforce that and empty a bank account. But you have no real leverage to get your client paid. Anything you do will, in fact, just be spending your client's money without a good result, right? Your client will have to give back whatever you garnish out of the bank account. You can't garnish those. You can't garnish the social assistance thing. There are no other assets. So when that client comes to see you and you assess the second part, is there a cause of action? Yes. Can my client get paid? If that answer is no, then you should not be taking money from that client. Okay. And, you'll learn a lot about ethics and the rules and that, but that's a practical application of it for you. It's also good business sense, because if a client comes to see you and you say, you know what, you don't need me, send them a letter, do this, this will fix it up for you. You go handle that, right? I understand you've got unpaid fines, sir. You go down to the courthouse, you make a payment arrangement, this payment arrangement, and they will allow you, once you get on that, to get your license back. So you don't need me for that. You can go do this. If you have problems, come and see me, but you don't need me for that. Or conversely, I understand you've got an order for payment. We can't enforce it. Therefore, we won't take you as a client. We'd just be basically spending or putting good money after bad. So anybody have any questions about that concept? Or it's a good spot for some discussion about when and where, what situations you're acting in, right from the basics.
And again, so I'll reiterate, you can unmute and ask directly, or you can just type in the chat, either way.
Quiet bunch this morning. Okay, so if then you satisfy your first two things, there's a cause of action, and you believe that if your client gets an award, they can get paid, then the next part is you look at your case. And you would then start with what's called the theory of the case. So anybody got any thoughts on what the theory of the case is?
The law, the type of law that you could apply to it.
Absolutely.
Legal analysis?
Yes, the legal analysis is very important. Yeah. That's when you perform this early on, right?
That's right.
Yeah. Any other thoughts on what the theory of a case would look like? Okay. Let's give you a scenario to work with, makes it a little easier. Say there's a home renovator, a contractor has come to see you, and he has an unpaid invoice. And he tells you that the person is not paying him, and they're claiming all kinds of deficiencies with the work now that he's done the work. Okay. There's a homeowner, so there's a good chance your client can get paid. There's been work done. What then would be essentially the theory of that case?
First things I would like to see the contract.
Okay.
To
But
see
think
what-
about it in broader terms. There's an action,
Okay.
right? So you're going to want to see the contract. That's the evidence part of it. But the theory of the case is basically unjust enrichment, breach of contract, but your client did work, hasn't been paid. It's that simple. And it's very important that you write that down and sink it into your brain before you go into small claims court. Okay. If you get
Sorry,
into
sir, sorry. Would you mind repeating that, please?
Sure. So it's very simple. Your client did work and didn't get paid for it.
Yeah.
Very simple, right? Keep it as basic as you can. Write that down and go into court. Okay.
Got it.
If you don't focus on that, you can go into court and you can find yourself up against a paralegal, and you can find that your client in cross is so badly beaten up from the settlement conference and from the defense, and is feeling defensive about their work. They're going to want to defend their work. They're going to want to do all those things. You as an advocate for your client, okay, that's not when you do those things. Your job in this particular case is to make sure your theory of the case is my guy did the work, it was done, he hasn't been paid for it, he rendered an invoice, they're not paying him. And you do not try to justify or cover off everything else. Straightforward, simple, work done, not paid, right? You don't want to allow the topic or the theory of the case to become about the quality of the work. The minute that happens, your guy is not getting full dollar. And now you're struggling to get him any dollar. So long as the discussion is why that invoice is not paid, what's the ability to pay the invoice? The stuff is there, you're using it, you got to pay for it, you contracted for it. That's the discussion you want to have. Everybody understand that?
Yes, I do. So keep it simple. And stick to the fact.
So your theory of your case is what's most important. And from there, you'll flow out the evidence. So now you come to your contract, right? So you have a contract that says this was going to be done. Here it is. It's signed. It's dated. It's got all these things on it, right? And this is what's done. Here now is my client's testimony. My client says we did those things. Here's the invoices for the materials. We went in, we did those things. Those are done. And here's my client's demand letter, my invoice. And here is, we're still not paid. We want to get paid. Exactly that. Yes, Roxana, you're right. You spell it out, right? You force the other side to then try and discuss the work, but they have to bring in expert evidence to do so, and you'll attack that. Your job completely and 100% right from the get-go is to focus on the fact that your guy did the work that was contracted for, and he's not paid. And everything else that you're doing is to bring it back to that point. You have to control basically how the court hears the case. You have to control the conversation, bring it back to your main points. Okay? And keep that in front of the court. Now, I see that somebody else typed in there, conduct legal research. Absolutely, right? You're going to want to learn the cases, see the cases, and when you draft your claim, you're going to want to use the language in the cases that most match up to your fact scenario. So you don't basically do your legal research before you go into trial. You update it then. But the optimum time to do your legal research is early on. Your client's going to spell out for you what the facts are. And you're going to find cases that fit those facts and see what the law does to them. If you have a chance to do that before you advise your client, that's the best. And then you use those cases, which you have saved in a case law folder, right? So the very first thing you do in this business is set up a computer system. You set up a case law folder, and every time you read a case and you save a case, you put a quick note on there so that you can find that and use those legal principles, because they will cross boundaries. That will be invaluable. So again, an aside on that is, remember to build a case law filing system. Okay. Now, when you get your case law put together and you read those cases, you actually can lift concepts, sentences, and put them into your statement of claim, so that you're subtly reinforcing what you're going to say in your closing, and you're doing that up front. So right at the start, you're going to say, oh yeah, these cases fit, and I'm going to adjust it. Now, again, like all battle plans, things change over time, but that should be your gold standard that you're doing. And most times that will continue. You will trot out that case that you looked at before you drafted your claim. You said, okay, yes, this is the fact scenario. This is how I want to present this. My evidence fits this. Then you use that. You'll use it in your closing. You've used it to draft your claim. You get a lot of use out of that one case. What websites do you like to use for legal research?
Canly so far. We use Lexis too, but Canly mostly.
Canly is good. Lexis is good. I think QuickLaw now has the CED, which is also a good starting point, in particular if you don't have the reference case law built up. So when you're first looking for cases, that's a good spot. It's a good, the Canadian Abridgment, the Canadian Encyclopedic Digest for legals. You do a quick review or a quick look up on the concept or the law, and it'll give you a number of cases that can jumpstart. Once you start, you get those first few cases, it builds quickly.
And if I might just clarify, so you said before we actually write out the claim,
Yeah.
we do our legal research.
Yes.
We find out what law that was impeded, and then we work our case based on the legal research as well.
You can draft, absolutely. So you draft your claim, and literally, like, you know how everybody has precedents for certain types of claims and certain types of language that fit scenarios.
Yes.
And you're always looking for the precedent that fits your scenario. But people underestimate the value of reading a case and making your case sound like that case. You can use literally case law as part of your precedents. So you're lifting the concepts directly into your claim. You're drafting your own precedent, but your precedent is coming from the case law that supports your fact scenario.
Perfect. Thank you.
Okay. Now back to what we were talking about, the theory of the case. There's an old story that goes, you know, if the facts are with you and the law is against you, then basically you lean on the facts. Okay. So if you have a fact scenario that makes your client seem very sympathetic and deserving, but the laws, you know, maybe not. So you're going to spend all your time arguing the facts, right? If, for instance, your client's not so nice a guy, but the law says that a contract is a contract, so you're going to spend your time arguing about the law, right? So like I said, you focus on the theory of your case. And if the facts in the law are against you, then you're going to want to basically, you pound the facts when you have the facts, you pound the law when you have the law, and you pound the table when you don't have either one. Okay.
Thank you.
The reason, what that actually means is, like I was talking about. So the example I gave you was a relatively recent small claims case where I inherited a client from another paralegal, and she was being sued by a contractor for work. And she said it was deficient, it was this, it was that. But, you know, she didn't have a lot of expert evidence, read none. And she didn't have a lot of witnesses to what had gone on, read none. But what happened at trial was the other paralegal made a couple of procedural issues early on that I basically jumped on and pushed hard at. And they thought then that there was going to be a fight initially over those legal issues. Of course, that was window dressing. And when we got there, we got right to the case. But I immediately changed the case, and the discussion went from why the invoice wasn't paid. They started in chief because the paralegal got flustered and forgot about the theory of the case. Most of the chief testimony in chief was about the quality of the work. And from there, it just went downhill for them, because what had happened was now the case was about, you know, how badly he had done the work and all the mistakes he had made. My client ended up winning a small counterclaim and getting costs for work that realistically, if you looked at it, you know, I'm not going to say that they weren't entitled to their judgment, but it could easily have gone the other way for the invoice as well. The difference that day was because the paralegal forgot why they were there. They forgot the theory of their own case and were more concerned with the window dressing around it, the pounding of the table, than the facts. Okay. So you got to pay attention. You know, you'll see people sometimes in the discussion groups and that they get upset because paralegals said or a lawyer said something nasty to them. Window dressing, fluffery, okay? And the minute somebody finds out they can get your goat by doing that or get you off topic, your client is in jeopardy, and so's your career, right? You have to focus, theory of the case, keep it simple, understand what you're there to prove, bring your evidence to prove that. Any questions or?
Now on that point, what advice can you share about kind of maintaining sort of cool there when someone is pounding on the table? How do you not let that ruffle your feathers? And I know particularly, let's say you're going up against a lawyer or something on the other side, and they see that you're being a little bit timid. How do you not let that get to you? What tips do you have?
Yeah, it's not the easiest thing in the world. But the first thing is to realize the minute you see somebody doing that, it's because you got them on the run, right? You have to realize that what it is. What you're seeing is a show, okay? And if I'm giving you a show, it's because I've got nothing else. I'm giving you a show to distract you. It's a magician's trick. That's all it is. So the minute you see somebody doing that, right? They're holding up the pen. Oh yeah, and this pen, right? Famous one. If the glove does not fit, you must acquit. Who the heck cares, right? I mean, realistically, if you're talking about whether or not a glove goes on a hand, whether it's been stretched, who cares? That's got nothing to do with anything, right? But if they're holding it up over here, it's your job to understand at that point, hey, wait a minute. This is good. This is really good, okay? And you let them go. You can let them make all the noise you want. And then you really come back to your thing and you say, my friend's comments were wonderful. It's an interesting theory. But what actually happened is my client came in, he did work. He did work in accordance with the contract. He gave an invoice, and we're still not paid. My client's points don't explain any of that, right? So you just redirect, bring it right back in. And you can feel comfortable at that point, even if you're feeling you're out of your depth. The minute you see somebody going off like that, you know what it is. Okay, understand what it is. Don't be intimidated. You just continue and repeat. Okay, so long as you're not trying to reinvent the wheel, you're not chasing their rabbits and their holes, right? You know what you got to prove. You know your case, and you stick to it, and you redirect the conversation back to there. You don't have to make it all theatrical. You don't have to sound anything except for this is what it is. You have to keep focus on where it is. This is the theory of my case. You don't say it that way, but my client did the work. My client gave an invoice. My client has not been paid. Anything else is just an excuse not to pay my client. But my client did the work, gave the invoice, didn't get paid. Right? So yeah, there are times in court too when you will get flustered. You can always ask for a bathroom break when it happens, rather than try to continue. Okay, at some point in time, don't be afraid to stand the matter down and say, "Excuse me, Your Honor, I'm having a personal issue. I need 2 minutes in the washroom," you know. And yeah, it looks a little silly, feels a little bad. Get out of Dodge when you're overwhelmed. Regroup in 2 minutes and come back. Okay. Don't let somebody bully you into something. And this is important in settlement conferences as well, because a lot of the deputy judges tend to bully paralegals and clients, and they'll be more effective at bullying your client in the settlements sometimes. And you got to be telling your client before you go in that can happen, right? They're going to press really hard, and you're going to tell your client if they're feeling overwhelmed, just say, can we step outside for a moment? And your job is to do that for your client. And your job is to also self-monitor, know when you're over your head and say, 5 minutes, gotta go. All right. Any questions on the advocacy side of stuff so far?
Perhaps maybe you can address one thing here. What happens if you have your theory of the case from the outset, and maybe you get another piece of information from the other side, or your client comes in, hey, I found this initial quote I had about before I gave the invoice. Do you stick to your theory of the case, or what do you have to do then?
Well, yeah, I did briefly mention that is it doesn't always hold up, and there will always be a need to change, to adjust, right? So you have your case, and say your client has, you've been pounding the table. Your claim is they haven't paid a rent cent, and these people are just avoiding paying. And then your client shows up and says, "Oh, by the way, I'm sorry, my bookkeeper reminded me they made a $15,000 payment on the $22,000 invoice, and I forgot to tell you." Well, you just went in there and lambasted them. Your claim says they haven't paid a red cent, and now you got to kind of regroup, right? You modify the theory of your case if you can, right? If the theory of your case is gone and you have no cause of action, then you have to be prepared to tell your client bad news. If they've paid the invoice and we're here suing them for the invoice, right at the moment, we're going to make an offer to settle, and you're going to pay them $1,000 to get out of Dodge because you really needed to know that. And, we're going to do it because we're going to save you $3,000 in court costs. That's the best action we've got right now. Don't be afraid to look unpleasant news in the face. Always, always, always protect your client. Okay. Your job is to protect the client, not to protect the theory of the case is important for what you prove to court, but it is not more important than your client. and it is not more important than the resolution that you're after. Right at the start, you find out what your client wants, and you may have a picture perfect case. You may have 10 people lined up outside the door ready to go, and it's a $25,000 claim, and your client gets an offer, $18,000 to settle, that they had said they would take. Your job then is to say, you know what, I put a lot of work into this, and I really want to run this trial, but my client is happy with that $18,000. All that work I did was to get them the $18,000. Your job is to take the $18,000 at that point, okay? Because nobody ever knows the outcome of a trial, but you should always know what it is that you're trying to achieve for your client. And when you get to that, that's when you stop, okay? You agree with your client, you check in with your client, and you're always on the same page about what you're looking for. When you get there, you stop, okay? That's it. You've done your job. Your client should be happy with that. Okay. By the way, one thing that you should always attempt to do if you can is if you can get into talking with a POA place and get into doing their pleas and that sort of stuff, even if you're just doing it for court time, right? You're not charging them anything. It's invaluable court time that will save you and your clients a lot of time and effort going forward. The reason why I say provincial offenses is because a busy provincial offenses office, sometimes we'd go in, we'd have 30 or 40 files in a day, and you'd be doing 8 or 10 or 12 or 16 on a docket, and you'd be rhyming them off, right? A lot of them would be set dates or agreed upon pleas. Invariably, during those appearances, not only do you get more comfortable in court, but invariably, you'll have a different justice of the peace that will ask you for something that you don't have. Okay. The moment that you get asked something from the bench, okay, that you don't know the answer to, is invaluable experience, because it's going to happen to each and every one of us in practice. What you want to do is have it happen on a set date, or you want to have it happen on an arranged plea, right? You don't want to have it happen in the middle of your first trial. You want to know in the middle of your first trial, when the judge asks you something and you don't know, you want to be able to say, you know what, Your Honor, I'm afraid I don't have the answer for you, but let's stand down, I'll go get it. You don't want to be panicking trying to come up with something. You want to have had that panic first if you can, okay? And trust me, you will always panic when the judge asks you that question. You've been doing it 20 years. You get asked that question. It's like, ow, that was a truck. Okay, I did not see that truck coming. But you have to understand, trucks will come. They're going to hit you. You just have to say, okay, give me 2 minutes. Be right back. Just going to check it out, see how many bones are broken, and I'll come back and let you know what's going on. Okay. If you can get, though, a volunteer thing, even if you just go to the courthouse and track down a couple of POA guys that are doing pleas and get them to let you do their speaking courts, it's invaluable because it happens so fast, right? I found that after I'd been in the business probably 10 years or more when I started doing provincial offenses, and I'd done a lot of small claims and some landlord tenant board stuff and some pretty high powered negotiation. I found that after doing POA for a couple of years, everything else had slowed down even more. So it does help. The in-court time is invaluable. Any questions? Anybody would? No. Okay, so yeah, go ahead.
I was gonna say, perhaps maybe since we're talking litigation here, do you have any tips with respect to questioning or making your closing submissions? And we're at that stage now, let's say with you're gone through trial and the other party is getting up there and they gave their position through their counsel, and now you may have a chance to cross-examine them. What can you share with my students here?
All right, sure. So cross-examination comes from knowing your case, knowing what you have to prove. Right back to the basics, right? So when you go up and you cross and they've just given all this stuff about why, for instance, your client's job was so bad and all that stuff. So you bring them up and you get the cross. Now, what you want to do is bring the conversation back, okay? And you want to say, here's your what's this document? This is your contract. Yes. Did you sign this contract? This is what it was for. Yes, 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 yes. Okay. If your client did all the work, if the contractor did all the work, your client did this, your client did this, your client did this, right? And all those things, you're just going to get them used to saying yes to and confirming your case, okay? When you get them to confirm your case, you've just reinforced everything, and normally you leave it there. If you're going to ask any questions, you want to know where they're going, okay? If you don't know what they're going to say, then the only time you ask that question is pure desperation, right? You have a hunch, you better play it if that's the only card you have left. But basically use cross-examination to reinforce your case, reinforce your position. If you can lead a person to an admission that they're not going to want to make, typically it's better done politely, and you lead them through a series of questions that they agree with, and you lead them back to where you want to be. Spend a lot of time. There's a pocketbook of evidence that I like, and get your own. And, find your own little pocketbook of evidence you can bring with you so you have access to what's admissible, what isn't quickly when you need it, because you're not going to have time to leave the courtroom and go find it. But if you're going to make an objection, then you want to have that little book with you, and you can call up a case on your phone if you have to. But always have that with you. Cross-examination should always be something. People say it's an art. You can watch it on YouTube. There's some really good cross-examination courses there you can look at. Sorry, there was a thought that I had, and I'm just evaded me for the moment on what we're talking about on cross. I can tell you the reason why you don't ask a question, though, is I had a provincial offenses case in Brantford court, and it was a particularly nasty case, and it was a failed to remain and a careless driving charge that should not have been. It was a case of teen angst, if you will. There were probably 6 or 7 teenagers in one car and 3 teenagers in the other, and they were all doing stuff they really probably shouldn't have been doing. And at one point, the 2 cars touched, and thankfully nobody was hurt and there was no damage done. But the prosecutor was, not dealing with it as a teen angst thing. He wanted his full pound of flesh, and said, yeah, okay, we're running the trial, if you're not going to resolve it down to something reasonable. My client's on the stand. My client is 17, right? He's in grade 12. And the prosecutor is up there and he's trying to get at him. And my guy is saying, look, there was no damage. That's why I left. Everybody knew everybody. I spoke to them. This is not a case of anybody leaving the scene, of an accident. There was no accident. And, we had some other stuff going on, but, there was no car accident. And the prosecutor then asked the question, well, how do you know there's no damage? Do you have any automotive experience? And I didn't know this, but apparently my client had been helping his uncle in his auto body shop since he'd been 12. And he was able to describe in great detail what the insides and the backsides of front fenders and what goes into the parts and what the chemicals are and all this stuff and what the underlying supports were and the fact that there was no damage. At 17, the prosecutor, of course, had fallen right into the trap by asking the question, and he didn't know what the answer was, but by the time my guy had finished answering, there was no question that two things. One, he'd been helping his uncle an awful lot since he was 12, which made him a pretty good kid in the eyes of the court and everybody around. And two is he had a pretty extensive knowledge of automobiles, and his experience, his opinion was more valuable than anybody else's at the time. So that's why you don't ask questions that you don't know the answer to unless it's absolutely 100% necessary. If you're ever in a position where you have to impeach a police officer, don't do it unless you're 99.9% sure you can do it, okay? Getting angry and accusing police officers will lose you pretty much every POA case. And sometimes when you win and you impeach the police officer, it's still going to hurt your reputation with the justices of the peace. So make sure if you're going after a police officer on the stand, you have to do it, and then make sure you get them. Don't do it halfway. Don't ask a few nasty questions and back off. It's all or nothing when you do that. And it has to be for a really important reason for your client, and you have to get it done for your reputation. It has to work. Okay, so be sure when you do that on a POA case. In terms of cross-examination and research, knowing what you have to prove is essential, and using that information to elicit information from the other side is important. Know your objections and have a sense for your objections, but more importantly, know that you're going to get hit for asking leading questions. Know what a leading question is, and if you do that, you'll be better than me, right? It's a sliding scale, it's a slippery slope, and that's what makes it a good objection to interrupt if your client is getting hammered, okay? A leading question can't contain the answer into it normally. You can ask a leading question to a hostile witness if you have them declared, or to the other side. You normally can't lead your own client, but in the interests of practicality, you'll be expected to lead your own client. Otherwise, everybody would be in court for like a 10-minute trial, would be there for 6 years. People get nervous, they forget. So what's going to be a fine question at one point in the trial to get the information out of your client is not going to be so good later on with a different client. And you're going to get used to the fact that people will use objections to interrupt you. You can also use objections similarly, but know in your heart, have a good idea of what a leading question is, and don't ask them. Don't ask open-ended questions to the other side that allow them to permit a different answer than what you want, right? You put them in a box and you get them to answer yes or no. If you leave it open so that they can express an opinion, they're going to express that opinion, and is not likely going to be one that's favorable to your client. So frame your questions in such a way that it's yes, no, or a specific answer, and shut down everything else. Okay.
Question, maybe switching gears here, because at the outset you were talking about on the town hall meeting tonight at 6 p.m. there with OPA. And yesterday we had George Brown on, so the perfect segue here for you is maybe you can reiterate what are the advantages for students to join the Ontario Paralegal Association, and what have you taken out from your experiences there?
Well, sure. When I first started in the profession, I didn't have any sense of the profession, but I joined the Paralegal Society of Ontario because they were pretty good at reaching out to the school and to my placement. And from there, you know, I've been involved in a little known thing. We had errors and omissions insurance since since I've been involved in 97, it predated me. So lots of paralegals in the organization were more professional. They did have backups. They did have colleagues. They did have people they could ask questions for. even pre-regulation. At the moment as well, and you'll hear this tonight at the town hall meeting, you will see a bunch of people that have presented and are working on various ends to include the profession in new areas of practice to help paralegals now that so many of our venues are closed for COVID-19, to expand our knowledge base and to make it easier for us to find our colleagues, if you will. Something like, for instance, the Docket Watch initiative is supported by the Ontario Paralegal Association. And while Docket Watch is right now, and we're waiting for the courts to reopen before the official launch. But what it is basically when you go into court and all these things we just talked about, you don't know them. You just see people up there talking and you have no clue. But what Docket Watch is going to do is it's going to allow you to look and say, okay, there's 12 cases in court. This is a small claims one with a contractor. Hey, I kind of interested in that. So you look at it, maybe you can, some paralegals will allow you to contact them. Maybe you can look at pleadings. You can certainly talk to the paralegal, get an idea of what the case is about and what you're going to see. Then you can do a little bit of research and put yourself in your own shoes. Okay, how would I present this case? And then when you go watch it in court, you have an understanding of what's going on. And that's the most important part. You can now relate what you know and the legal concepts that you've learned and the research you did, you can now see how another paralegal will put that forward. So that's the kind of things that you get out of an organization like the Ontario Paralegal Association, as well as the pull they have. The lead speaker tonight is the treasurer of the Law Society. So, all right, Chris, have a good afternoon, and I see you're off to a client meeting, so have fun.
Yes, thank you. Have a good afternoon, everyone. Sorry about that.
Okay, no problem.
See ya.
Yes, any other questions there? Just make sure you get your chance here to ask Bruce.
No, okay. So maybe, John, I can give you my email address in case anybody has a question or needs the link. And there's also the different chat groups online. They're a little bit more robust sometimes, but certainly we'd be happy to have anybody join the various groups. So if you want to give me an email, I can set you up with some of those as well.
Perfect. So thank you so much for joining us today morning. Perhaps if you have any final words of wisdom that you'd like to share here with the paralegal students as they enter into the profession. And again, thanks for joining us.
All right, a couple of quick things. Set up your case law folders. Okay, I neglected to do that, and I've done so much research over the years, about 12 times, that I didn't need to do. I would have been much quicker. So set up your case law folders, remember your case law, remember your theory, and keep focused on what you do. Trust your instincts and stick to your guns. All right. Don't be afraid to ask questions. Lots of senior paralegals out there will be more than willing to chat with you. Okay.
Thanks, Bruce.
Thanks, everybody.
Thank you,
Thanks,
Bruce.
Thanks.
Thanks, Tracy. See you tonight.
Thank you, Bruce. Take care.
Yeah. Take care. See you tonight.
All right.